recording this right now. So thank you everyone for joining in. This is a webinar that we wanted to provide you. Obviously, we're in hurricane season right now, and we wanted to provide you with some information on what to do kind of preparing for as we're in hurricane season, but before we have a storm approaching, what to do when there is a storm approaching and some actions you can take. And then what do you do afterwards in terms of some information regarding the filing of claims and so on. So before we get started, just again, I'm Ed Ronsman. I'm a partner with McCabe and Ronsman. This is Pilar Dixon. Pilar's with Brown & Brown.
Good morning.
So thank you all for attending. I know we have a number of people on here. And the other thing is, before we get started, if you're new to Zoom, I'd be surprised if you're new to Zoom right now because of everything that's happened with COVID-19, and we've taught a lot of webinars, and it's kind of the best way for us to provide you with some information. But this is a webinar format, so the one thing you can do is if you go down, there's a Q&A button. If you click on that and type in any question that you have, it's going to pop up to us. And I'd like to handle questions that way. It helps us to make sure that we see them, and it kind of sorts them for us to know which ones we've answered and which ones we haven't. We might be able to answer them during the webinar, but I want you to stay to the end because we'll go through any ones we weren't able to answer if we're going to hold them. And so we'll have some important information at the end. I know lots of you will have some great questions with this. So that's the best way to handle it that way. I'm going to share my screen here. And you all should be able to see our PowerPoint that we're going to be going through. If you'd like to email me afterwards, I'm happy to provide you with a copy of this if you're part of a board, or if you're a manager and you'd like to provide a copy of this to any board members that you work with, we're happy to provide you with a copy of it. So some of the topics and objectives we're going to be going over before the storm. What can we do during the storm? If there's a storm approaching, we're in a state of emergency, what are we allowed to do? Immediately after, and we'll talk about making a claim. The objectives that we have here, we want to help owners understand what you can do to protect your homes and your businesses. And really, when we talk about businesses, it's your association. And as a reminder, and I teach this in my board certification class, that an association is a nonprofit corporation. It is a business that you're operating. It's a nonprofit one, but it still is a business. I know that some of you on this, and we do work with some communities that do have rental programs, and there is more of a rental revenue. There's an income stream there that differentiates you from other associations that, and Pilar will talk about it a little bit from a loss of business standpoint. Right. We'll talk about management duties, what you can do today and then right before the storm, how to protect your rights, and then how to make a claim and when to ask for help. Everybody's probably seen this before. We're going to be, as we get closer to whatever the peak season is for us, when we start seeing hurricanes. In Florida is, what are these, the spaghetti models, right? And everybody's going to be seeing this. And I know I have an app on my phone that when you're tracking these storms. So Pilar's going to talk about preparing even when a storm isn't imminent. You can talk about
Sure.
some of the things like the different coverage types.
Yes, exactly. So one of the most important things that you can do now, like right now, this weekend, is create a plan with your family and loved ones. If you know that your family is taken care of and that your loved ones will understand the plan and where we're going and what we're doing and how they can all contribute to your hurricane kit and getting your household prepared, then it's easier for us to serve our clients, our associations, our boards, and to assist in that manner, knowing that our family is taken care of. One of the most critical things that you can do now as a property management firm, a board, an association, is to understand your insurance coverage and the deductibles on your policy. Whether it's your property policy, if you association purchases flood insurance, or your casualty coverage. Most of the time, people don't even think about the fact that they may need to report a claim under their general liability in the event that someone's gotten injured during a storm. So making sure that you have a full understanding of your insurance coverage, and particularly the deductibles and how they will apply. And do you know if you have enough coverage, not only for your home, but does the association have adequate limits for, based on their last appraisal Or on your homeowner's insurance, do you understand your deductibles? Do you have replacement costs? All those things are critically important to understand before the storm, because right now, if you needed to make modifications, you can. Remember, insurance companies will no longer allow increased limits of coverage once the storm is, like we say, in the box. The other thing to think about when reviewing your policies on your home, for an example, do you have adequate coverage for your contents? If you have a beautiful lobby and you have a beautiful pool and you have a lot of contents, business, personal property, make sure that you have coverage for that as well. And like Ed mentioned, that we have some associations that have rental units and you're highly dependent on that revenue. Make sure that your policy provides loss of business income. One of the most critical things that you can do now is gather what I call a document kit. You're going to hear every news station out there talking about having a hurricane kit with your typical things, your water, your batteries, your flashlights, all of those things. But you need to have a document kit. And that would include things like an inventory, appraisals, inspections, pictures and videos, your insurance policies. And while you're putting all this together, make sure you have hard copies and backup access. We may lose power, so you need to make sure that you have all of those documents, if not hard copies, but on the cloud or a thumb drive. I also want to really emphasize the importance of documenting both before and after the storm. The easiest way right now, you know, most of you that are parents have your children at home. They love playing on your cell phone. So give them your cell phone and tell them to take a picture of everything in their bedroom, and then assign them the kitchen and the laundry room and the living room, and just document what you have in your home. Obviously do the same for your business.
And Pilar, I'm going to put you on the spot. Can you talk a little bit about the difference from a condo perspective versus maybe, I know we have someone here that might be in a townhome association and the different types of policies. And I think that I've seen where sometimes owners in townhomes, for example, when they get a policy, they think they're getting an HO6 policy. Right. When it really should be an HO3. Can you talk a little bit about that?
Absolutely, my pleasure. So if you are in a townhome association, that means you're responsible through your roof. So you should actually have an HO3 policy, which is a homeowner policy similar to a single family dwelling. Those are critically important to understand. We don't want, if you've got 6 units in a townhome, you don't want one of the families not to have the accurate and adequate coverage to cover that. Versus in a condominium association, you're going to have a master policy ensuring the exterior of the building, and then as an owner of a condominium, you would have an HO6 to ensure your additions and alterations inside your unit as well as your contents.
So I've seen that where some communities, we do represent some townhomes that actually in the governing documents, the association actually insures the roofs, for example.
Right.
And I would say that's more uncommon, I would think, for townhomes.
Correct.
We've had instances where there was a storm event and owners came back and said, I have an HO6 policy. I don't have coverage for this, because sometimes I guess they hear it at a townhome and they think it's just like a condo, and that's what they give them. And so I think for some communities, if you're in a townhome association, it might be worth sending out in your next newsletter, reminding people that this is a townhome. You should take a look at what type of insurance that you have, because we do not insure the building structure if that's the case. And take a look and make sure that the owners have the proper coverage in place.
That's correct. And if you're a property manager and you manage one of these townhome associations, I completely agree with Ed. It would be great to publish a document and even have them confirm back with you their insurance carrier, or that the fact that it is properly written. Having a good understanding of the documents, and maybe even sharing the document or that particular portion of the document that they can give their insurance agent to be sure that each owner has an adequate policy.
Yeah, great. So I wanted to talk a little bit about from a contract standpoint, and I listed 4 types of contracts. Really, there could be many more depending on the type of community, but the main contracts that a lot of you have are your management contracts, your landscaping contracts, your security contracts, if you do have security services, and elevator contracts. The reason why I put this on here is take a look if these contracts have anything specific regarding if there's an event, if there's a disaster event, some type of casualty event, or some type of storm, if there's any type of specific procedures or protocol in place, or what type of additional services you might be provided. I don't know that it's necessarily common in a lot of these to have that. And so if you don't have it as part of your contract, maybe take a look at talking with, if you're a manager, obviously talk about it internally. If you have a company policy in terms of how you're communicating with your associations, if you're a board member, talk with your manager and say, what's our contact information? Do we have the best information between a cell phone number, an email address, some different ways to get in touch with somebody, and then what's the procedure in place? You know, a lot of contracts provide for things under normal circumstances, like how many meetings does the management company attend each month? What, you know, property inspections, that sort of thing. If it's really hands-on type of response to a storm event, that may be something different. I think it's worth talking with your management company about, so that there's some expectations on the front end. I think going along with that, I put in here a project management fee. A lot of times management companies will charge that if this is really more after the fact. But if there's a rebuild, obviously if there's some really bad damage and you have to put a new roof on or whatever, if there's a substantial amount of damage and it involves overseeing some type of a reconstruction project, a lot of times that's included as part of the management contract as a separate fee from your management, normal monthly management agreement. So take a look at that and just make sure you understand it. The other thing I put under management is just work with your manager. They usually are pretty in tune, and they can are in contact with somebody like Pilar in terms of what policies you have in place. They can be kind of a liaison there. If you're not talking with your agent right away, work with your management company on that. The other thing from a landscaping perspective, same thing. What if do you have anything in there is there a fee for coming out after a storm event for removing, you know, tree limbs and stuff like that? Right. If you need to clear out damage, and if you don't have that, talk with them about it. I know, Pilar, I think we were talking about this just yesterday, about maybe having some type of almost like a hotline or something like that, or if there's an additional service that you can pay for to make sure that you're taken care of right away in the event of a storm or something like that, where you know that they're going to be coming out, I want to say a priority client or something like that, but that's something to look at.
Right. I think that's critically important. And one of the things that, you know, we're all going to have debris, right, after a storm, and understanding and making sure that you have conversations between the board, the management company, to have those conversations. Do you know if your community is going to have the debris picked up by the city? So is it just a matter of getting it to the curb, or is it getting it to the entry? So having those things, and understanding on those things, and then maybe an extra provision in your landscape contract so that you are a priority that you can call. And if your landscaping contract has the ability to also provide maybe a roofer, maybe you've got a tree on a roof and you need to get your roof tarped, but you got to get the tree off first, right? So I think it is critically important to have those conversations now so that you're not scrambling, you know, right before the storm or, you know, immediately after. The other thing I'd like to kind of throw in here is that document kit. You really should be, the management company, the board, should be having those conversations. Who has those documents? Who has that extra set of documents? Because who knows how, you know, how the storm is going to impact us based on different places. You may have someone that chooses to stay behind that's on site at the property that knows, you know, we've got trees down, we've got, you know, a roof off, and they're right there on property. And if they have, you know, if you've got a really strong communication plan, then you'll be priority for getting those claims reported. If you get a claim, you know, if you know there's damage and you get that claim reported quickly.
Yeah. I think just going in with the other type of contracts, the security contracts and the elevator contracts, again, security from the standpoint of if there's an evacuation order, or if there's anything, you know, from the fire marshal's office that basically requires you to have, like a fire watch in place, for example. Is that
Right.
covered under your security contract? I think that's really important to look at. What type of services do they provide? And if it's not in the contract, talk with them to see if there's some type of an addendum you can put in place or something that you can put as a policy, so that in the event that there's a storm, it's better to have this taken care of on the front end.
Right.
You're not going to catch everything, because what's going to happen is there's going to be a storm and you're going to say, we didn't think of this. I wish we would have included this. But
Right.
do the best that you can to have something in place. If you do that, I'll tell you that you're going to be ahead of the game for 90% of the associations in the
Yes.
state that don't have some type of a plan in place. And look at all the different type of vendors and professionals that you work with to make sure that you have a procedure in place where if a storm hits and you need to have additional services, how is that going to be done?
Right.
So security contracts are important. Obviously, if you're in depending on the type of community that you have, if it's a guarded, what happens if there's an evacuation order and you have a manned gate, for example, and they can't get anybody over there, or if the gate's down. I mean, there's certain things that you should just
Right.
discuss with them as to what their procedure is. They probably will have that, and you might just want to get that in writing from them. From a legal perspective,
Exactly.
I want to make sure you get it in writing so that if they don't perform underneath it, you have something you can rely upon later. So
Right.
that's why it's always important to get something in writing. And then elevator contracts, especially for condos, high-rise condos, it's critical to know what their policy is, what backups do they have in place, how quickly can they get out, because depending on the type of residence that you have, you don't want to have somebody that can't get down unless it's going down 12 flights of stairs because the elevator's out for an extended period of time. Will they come out and will they raise up your elevator to make sure it's off
Right.
in terms of like a water event, that kind of thing, to
Exactly.
really make sure that look at your contract, and if it isn't covered in there, make sure that you reach out to your vendor so that you have a procedure in place.
Absolutely.
Yeah.
So we're going to talk about the difference between, is it flood or is it wind? And in a major event, this is very critical in understanding your coverage. Windstorm coverage is typically included in your property coverage. You need to verify that. You need to understand your deductibles. If it's a flat deductible or percentage deductible, is it a hurricane higher percentage deductible, a named storm deductible? We can talk about different types of deductibles for hours, but we're just going to, at this point, let's talk about the difference between a windstorm event and a flood. If you have a hurricane, you're going to have potentially both flooding and wind. So if you only have a property policy that includes wind and you don't have flood, and you have rising water on your property coverage is going to exclude that rising water. Now, if you have, I always like to use the example, is it rising water, or did the roof blow off, or was the roof penetrated and we have water coming in the building, the structure, through the roof? Obviously, that could be considered a windstorm event, not flood. Flood, remember, is an inundation of rising water. We always get questions, do we need flood insurance? I'm not in a flood zone. Well, everyone is in a flood zone, but if you're in a high hazard zone and you're required to carry flood, if you're a single family dwelling, or if you're in a condominium association or a townhome association and the building is in a high hazard flood and you have a mortgage, you're going to be required to carry flood insurance. So that's going to dictate that. So that's the first thing. If you were in a non-high hazard zone, for an example, flood zone X, by the way, more claims are paid in the lowest hazard zone, in the zone X, than any other zone. And but you just really need to understand and evaluate the cost to buy a flood insurance policy for your building. And I will tell you, remember that flood insurance by the federal program has a 30-day wait. So no matter if you're getting your flood through your write your own companies, which are carriers that just issue the flood policies on behalf of the National Flood Insurance Program, everybody complies with those rules for a 30-day waiting period. The exception to that is if you're buying a private placed flood insurance policy. Most of those are placed through the Lloyd's syndicates, and those do not have a waiting period typically, but you would just have to make sure you have a quote, and that you have a bindable quote, and don't wait until the last minute to try to get that coverage in place. But just understand also that our surrounding counties have recently been remapped. So if you're live in a single family dwelling, your own home, and you haven't had your flood zone checked in a while, you may want to do that. Call your agent, get them to run a quick flood zone determination for you. That information is also available on the City of Jax website or the county websites if you're in other surrounding counties. But you want to make sure that you understand your possibility of flooding and then obtain a flood quote.
I'm going to put you on the spot again one more time. Can you talk a little bit about depreciation in terms of what's covered in terms of RCV versus ACV in terms of these policies?
Yes.
Yeah.
So your property policies and your homeowner's policies should be written on a replacement cost basis. If they're not, you've got a problem. It's typically right on the front of your policy, as well as your deductibles. Most of the face pages of your homeowner's policies now say you have a higher windstorm deductible, just because they're trying to make everybody aware. Yeah. And homeowners insurance policies 99.999% of the time also exclude flood. So you've got to be certain of that. If you are a unit owner, you could purchase flood insurance depending on the availability of limits based on what the association is insuring. But the policies, as far as actual cash value versus replacement cost, critically important for you to understand the difference. Understanding if your contents coverage is replacement cost on your home policy. Sometimes they are, sometimes they aren't. So you just have to check that.
Yeah. We wanted to include this. It has the top 10 most significant flood events and determined by payouts. And you can see that Katrina is number 1, Hurricane Harvey, and you go down, let me see, Irma, one of the more recent ones up here, Hurricane Matthew, 16 and 17 if we're in Northeast Florida. These are up there in terms of, we just wanted to provide this information. You can see the number of paid losses and the amount that's outstanding on those.
Right.
I like this picture.
I love that picture. Let's just get a moat.
Yeah.
Okay, let's talk about, as the storm approaches, finalizing your plans with your family and your loved ones. I hope you guys notice that we are really stressing that it's really important. One of the things we haven't mentioned is our new favorite 5-letter word, COVID, and the impact COVID's going to have on the availability of sheltering. And I noticed recently that the city of Jacksonville is putting out some information about knowing your evacuation zone and knowing your hazard for flooding. So, and sheltering in place. I mean, they're really asking people to understand that. So again, please prepare your family and your loved ones first. You may want to talk to your insurance agent again as the storm approaches. One of the things that's critically important, you don't want to be in the middle of negotiating your renewal when there's a storm brewing. And that can get really, really hairy, and it can get very frustrating. And that is just a critically important part of the process of communication. I would also at this point update your hard copies and reported contacts. We've talked about a lot of things in this communication of what all do you put in that document kit, who has it, who's going to be responsible, and really to put that burden on one person in a large association might not be realistic. So you might want to have multiple copies and understand what is our disaster plan and who is going to make those final decisions as the storm approaches, and make sure, again, you've got all those documents and you're taking them off site.
Even just from a technology standpoint, a very simple thing, like Pilar said, you want to have access to it. Just create some type of a secure Dropbox account or a G Drive account or something like that that's in the cloud, that whenever you get to a place that has internet that you can log into and that you have the certain number of people that can share it, that itself is easy and it's free in most instances, up to a certain storage space. And then from there, it's then, like Pilar said, is having the policy in place as to who's going to be our main point of contact, who's going to be making these, so that you're not trying to scramble after the fact.
Right.
And have, I hate to sound like this, have backups, because
Exactly.
somebody may be, for whatever reason, they may have a family issue, they may have something else that happens, and have it almost like a chain of command in terms of, if this person's not reachable, have this person. And having that in place, again, try to do it as far in advance as possible, so that you have some type of a hurricane or storm or procedure kit or something, even just a policy manual that you have in place, that then you update from year to year, that you have it. And then as your board changes or whatever it is, you may update the contact information, but you're not changing the overall structure that you want to have in place.
Right. So I would like to add, as the storm approaches, you need to be certain as well that you've got the direct contact number. For an example, you want to make sure on your homeowner's policy, let's take that one first, that you know the claims reporting hotline for your insurance carrier. And as storms approach and as hurricane season approaches, the Florida, the CFO in Florida will post the hotline numbers for all the insurance carriers, and you can easily go on that. If you don't have a copy of your policy, you can't find it in your policy, you can either call your agent or go on that website and pull that information off. You need your policy number, your address, and you need your the hotline to be able to report a claim. And I just want to remind everybody, the priority of getting a claim reported and understanding what your damages are is critically important. And as the storm approaches, if you haven't done that last minute video or you haven't taken those pictures, really, really important to be able to document what you had prior to the storm.
I've seen this guy out there. I think he was exaggerating a bit, but I always like to include this as part of our PowerPoint here.
It's one of Ed's favorite pictures.
Yeah. So the other thing too, even during the storm, and this really kind of, as you're crossing over here as the storm's approaching, and once you get into the storm, depending on if it's actually made landfall or if it's close or not, some things too are just like common areas, common elements. Take a look at your pool, any other type of amenity, anything that the association's responsible for. Obviously, it's going to be securing down any type of furniture that can't be stored away, stuff like that, because what you don't want to have happen is everybody's racing around and then they forget to secure down some of the chairs and everything, and all of a sudden the wind blows them up and it goes into somebody's window, and you have a claim that the association was negligent because it didn't properly secure that stuff. So also just take a look at obviously securing the common areas and the common elements to avoid any type of a liability claim. In terms of communications to owners, this is, if you've attended one of my webinars for COVID-19 in terms of what the association's duty is, there's a fine line to walk between, I think, providing information for owners versus making it look like you're taking on the duty to fully protect them, because what if you fail in that duty? Then that could give rise to a claim for negligence, for example, or any other type of claim that somebody might bring. So I think that the most important thing you can do as an association is say, be safe. Here's information that we have. Here's the hotline. Here's the county that we're in. Here's their emergency services webpage. Here's this, and continue to provide them with information so that they're informed. I don't think it's not the association's job to make sure and knock on everybody's door and pull people out of their units. That's not practical, although there is one of the emergency powers under the Condominium Act is the ability to require people to evacuate the condominium. But from that standpoint, it's not your job as an association, both as a board member and as a manager, to go in and physically remove people if they're not removing when there's an evacuation order. You can only do so much. But what you can do is provide as much information as you can in a manner as best possible. So like during the storm, if you leave, talk to your neighbors who are staying, take pictures, be prepared for the worst, understanding that, you know, every single time there's an update, was it every 6 hours, they'll have a new advisory. I even remember, I think it's at 10 in the morning, I want to say, I can't remember now. There's the intermediate one. I remember when you have a storm coming in, you're looking and there's the intermediate advisory every 3 hours. So things can wobble, but I would say, you know, prepare for the worst so that you come out better than if you're saying, well, it shifted a little bit, it's not going to make direct landfall over us. I don't think that direct landfall really matters all that much if you're still within the eye. And so obviously preparing for that is the most important thing that you can do. We've talked about this. Some of the stuff you've seen on here is, and Pilar and I, when we were talking about preparing for this, we both said, we need to keep on reminding people, have contact information for your insurance company and your broker,
Right.
your agent. Make sure that you have all this, because that's the most important thing for filing your claim,
Right.
and making sure you have a procedure in place, and obviously be safe too. I mean,
Right.
that's,
Absolutely.
yeah.
Being safe is the first part, because we need you to be safe. And again, I just want to stress what Ed was talking about, knowing who's staying behind, because you will have people that will stay behind. I always joke with my family, I get left behind because my husband is a hospital administrator. So I know that I'm going to be left behind in the storm, but obviously he's going to say, honey, leave or stay home. But I just think that it's critically important that you have a plan in advance with your family and with your neighbors. I recall in one of the storms, our lake was starting to overflow, and it was starting to overflow because the drains were blocked. And so there was a lull in the storm, and there was probably 10 people out trying to clear that so the water would flow. And I wouldn't go out. I was scared to death. I was like, please go back in your homes. Please go back in your homes. But don't take a risk. Don't take an unnecessary risk. Use good judgment and be safe. All of the things that we're talking about, building structures, contents of your home, all of that can be replaced. You have to be safe. You have to take your family into consideration first.
The other thing too, when you talk about that with the rising water and everything, a lot of you are in communities that have retention ponds.
Yes.
Most of you probably have them in some fashion, depending on the type of community. Remember, just don't expect those ponds to perform like they normally would, because they're not built to withstand hurricane type rains or, tropical rain, the amount of rainfall that you get. That's not what they're designed for. If you were to design it for that, they would look much different. I'm not an engineer, but I know we've had to look at this enough. And so don't expect that, well, we've got this system, even if I live on it, that it's going to perform, because it's not meant to perform for that. So have a plan in place, especially if you're a retention, if you use that as kind of a marketing tool to buy, you're on a lakefront. Well, it's also a retention pond that might not bring the water down as much as you think it will in a storm event. So be prepared for that.
Actually, I think we need to add lake management to our contracts to review in advance, to make sure that all of your pipes are clear. I know in my community, we actually have them videoed and make sure that they are clear prior to storm season every year.
Yeah. So here's a picture of after a storm has come through, and hopefully, that we don't have this. I believe this was in the Panhandle after Michael, if I remember right. So I want to talk about this, and some of you have been very familiar with this because of COVID-19 and the fact that Florida is in a state of emergency. And then the question is, how do we utilize these emergency board powers? So you have these, it's for condominiums, it's chapter 718, section 1265 of the Florida statutes, it's 720, 316 for HOAs. When you look at those side by side, they're very similar. There's some differences, but for the most part, the purpose of it is to use it when a state of emergency has been declared. And I have on here some of the emergency board powers. So some of the things are canceling and rescheduling meetings, naming assistant officers, relocating the principal place of business, entering into agreements with local counties and municipalities, whether it's for storm cleanup, if you're on oceanfront, maybe dune restoration, something like that. Declaring the property unavailable for entry or occupancy. We use this a lot for COVID-19. When the question came up, are we allowed to keep our pools and our amenities closed? Is that an emergency power that we have? The thing to remember is that the emergency powers were really drafted in a way for storm events, because it says that in response to property damage, you have these following emergency powers. And not to get off on a tangent, I know, but we're all in this right now still with COVID, that's been a topic of discussion as to, well, COVID isn't really property damage. It's actually keeping people from using the property because we don't want people close to each other.
Right.
But it is meant for something like this, for a storm event, anything to do with property damage, to take a look at it. So levying necessary special assessments without the vote of the owners, even if your documents might require certain membership approval. Obviously, if you have some type of a reconstruction, some type of cost that goes beyond what you have in the reserves, even if you might have to have 2/3 owner approval, you don't have to undertake that if it's in response to an emergency event. You can't use that for putting in that new, water slide that you wanted to put in for your community pool or something. This is really supposed to be in response to damage from some type of an event and where a state of emergency has been declared. The other thing is borrowing money and pledging assets as collateral. You might already have that authority, but it might be conditioned on membership approval. Again, you have that ability under the emergency powers. And then you may require, I mentioned this before, evacuation of the condominium or property in the event of a mandatory evacuation order. So you can require that. The difficulty, the question that I get sometimes is, well, what if they're not leaving? How do you enforce it?
Right.
And unfortunately, the best thing that I would say is provide them with written notification, whether it's you drop it off and you go and document and say, I handed this note to them saying that you're here in violation of our evacuation order. The association can't be held liable for anything that may happen, with your unit. Right. That way it at least serves as a deterrent later if something happens and they decide to name the association, where we can point and say, no, we advise you there was evacuation order and you needed to leave and you didn't.
Right.
Practically speaking, it's difficult to actually force it. Like you see, if you're in violation of a local order requiring evacuation, law enforcement, they're not going to come and arrest you or anything. What they're going to say, though, is you're not going to receive any emergency services if you're there during an evacuation. Right. So this is the big thing really for right after the storm. The main thing that I would recommend to you is don't fall into making decisions by email or by phone call that are big decisions that if you have a way to call some type of an emergency meeting, you don't want to lose it where the owners are at least able to participate in some way. I know it's not perfect and you're going to have to adapt and you're going to have to make certain decisions, whether it's a board vote or whether it's the president that authorizes it. But the statute does give you the authority to call meetings in a manner as practical as possible. So maybe it's a Monday morning and a storm just came through and you need to meet that night. All you have to do is post the notice, giving as much time saying, we can't wait 48 hours. We need to have this meeting tonight. Right. You still are required to do that. I'd advise against going the route of voting on everything by email because the statute prohibits it. And there's nothing that says in the emergency powers that you can vote by email. What it says is you can call meetings with notice as practical as possible. So still try to keep open meetings as best you can so that owners, and I think it's helpful for the owners to see the board that you're acting along with the manager, that they can raise points or any comments, and it helps with the dialogue there. But you don't want to lose it where the members feel like the board's off making decisions without their involvement that may really impact them down the line.
Okay, it's my turn, Ed, to put you on the spot.
Yeah.
So if you have a situation where, let's say, a couple of your board members left town,
yep.
And they have access to electricity in the website,
yep.
is posting that notification on the website for those folks that could possibly still have electricity and could access the website, is that helpful? Does that help comply with the requirements?
So there is nothing that says that you can post it solely by electronic means. There is a provision in the Condo Act that allows you to post via website in addition to the physical meeting posting requirements.
Right.
But the statute just says in a manner as practical as possible. So if it's not practical, for example, it's not even safe to go back to the condominium property or to the association that you're in.
Right.
I think that if you provide a way to say, look, here's our email list for owners that have consented to receive notice by email. We're going to email everybody. We're going to post it on the website and let them know. And you can try maybe calling people. I think as long as you do as best you can under the circumstances, nobody's asking a board member or manager to go walk over, if there's debris and everything that it's not, you can't go to the community. Don't do that.
Safety first.
Safety first in a way as best as possible. And I think then the board's going to be given the benefit of the doubt over an owner that might say, well, you didn't post this or you didn't mail me. Well, it wasn't practical for us to do it, nor was it safe for us to do it.
Exactly.
And so that's the way that I would recommend an association handle it. All right. So after the storm, going into this, only return when you're told that it's safe. Take photos and or video of the damage. Here's one thing, though, that I think it's important to note. If you have an attorney that you work with, in our law firm, we've worked with a number of our clients on this. One thing to keep in mind, talk with your attorney to see what procedures you have in place if you need to represent us on a hurricane claim or any type of storm claim. Are we charged hourly? Do you do it on a contingency? I think that's important to note. Because if you take photos and it's under the direction of your legal counsel, that could be considered work product. In which case then, if there's something that you may not want to have to disclose, it can be protected as a work product. So think about it like that. Obviously, if you've got a roof off, that you're going to want it, you're going to have all those pictures, you're going to want to provide those anyways. But it's something to at least think about as to whether or not you should engage your legal counsel, just so it's kind of like when you engage your legal counsel to have a closed meeting, you have them there for anything that's proposed or pending litigation, so that you're not waiving your attorney-client privilege unless you feel like it's something that should be brought up to the membership that's not involving litigation, right? So you can be safe on that side. And just think about engaging your legal counsel on it. Avoiding scams, and that really, I'm going to loop in the third and fourth bullet point here, because I think that a lot of scams were through contractors really coming in, whether they were in the state or really coming from out of state, and offering to do work and getting associations to sign assignment of benefits. And so the interesting thing with assignment of benefits was that the only case law that we've had is really where carriers were challenging the standing of these contractors or entities that obtained an assignment of benefits, whether or not they had standing to bring claims on behalf of the policyholder. And there's appellate cases that say, yes, they have the standing. The problem is that contractors abuse the process by making us, I don't want to say trick, but it's almost tricking associations into signing these one-page documents that basically say, for your policy, we will bring the claim on your behalf and you assign over any claims and rights that you have underneath it. And you won't have to pay us anything. We're going to get paid from the carrier and we'll do the work based on it. The problem is they didn't include any type of scope. And what we found for a lot of communities where they would make these demands on the carriers, and if they didn't get a favorable response, I kind of joked that they put it into a desk drawer and they just put it out of mind and they focus on the ones where they were receiving some traction on it. And so we had a number of communities, I know some of you might be on this, where they didn't hear back then from some of these contractors for 8, 9, 10 months. And they said, what are we supposed to do? There's damage to our property. And they said, well, we're still working with the carrier on it. So there was a change to the statute as of July of 2019 that effectively made it so that you're not going to see these contractors from out of state come in trying to get you to sign these one-page documents, because there's a lot of requirements in place. They have to put a scope of work. They have to notify the carrier immediately that they've been notified and what the scope is and what the estimated amount's going to be. There's more in addition to that, but it effectively has shut that down. So even though if you have somebody that asks you to sign one of these things, know that you need to have legal counsel review it, and it's likely not going to comply with what the statute provides.
Because there's still going to be contractors that are going to come from out of state that don't know about that new law that happened last summer. And it's really important. Those are definitely the types of things that counsel needs to be representing on, because you truly are assigning over your rights. And when you do that, it makes it very difficult for anyone else to help you, because really that contractor now is mandating and owns your policy. So the changes are obviously to protect the consumer all the way around, which is a phenomenal thing. But again, just you have to be you have to avoid the scams. You have to make sure that you're understanding what you're signing. And I would say the majority of the time that if you're getting an estimate, you're not going to be required to sign a one-page document that is shuffled in the paper. So just be very careful.
Be careful of it. The good thing though, that came in to protect, because when it started, it was a benefit to communities that didn't have the ability or the understanding of how to file these claims. And so it worked out where if they did the work and then they were receiving payment back from the carrier, and that was for lack of a better term, marketing idea, that they said, for us to get the work, we're willing to wait for the carrier to pay us. The problem was that the work wasn't being performed as they tried to see what they could get. And then now you have a roof. And then what happened was, it happened after Matthew, and then a lot of Hurricane Matthew up here in 2016. And then for the ones that they didn't jump on and do the work, then Irma came in, and all of a sudden these contractors came back and said, well, we need an assignment now for Irma as well, because they didn't document and they couldn't tell between what was Matthew damage versus what was Irma, so they needed to have both. And some of my clients that I work with said, no, we're not going to give this over to you. We didn't hear from you after we gave it to you after Matthew. So that's where there was abuse from it. And so just be mindful of that, of course. So going down the road, what has occurred in terms of what type of damage is there? And Pilar talked about flood claim. Is it a flood? Is it flood damage? Is it from a wind-driven rain, issue? The carrier likely, once you file that claim, they're going to come out and investigate it. They have the ability to come out and investigate. Do you need to hire a third-party adjuster or a private adjuster? I know we have some private adjusters on here and that I've worked with, and that can do a very good job for you advocating for your community. There are also some not so great private adjusters. And I think it's very important to make sure that who you're contracting with ask them about their experience, the volume of claims that they've handled, ask for references, talk with other communities before you do that. For those of you that don't know, a private adjuster is somebody that you basically hire to advocate on your behalf to be able to negotiate with the carrier on behalf of your claim and adjust the loss. And typically they're paid on a contingency, a percentage based on the claim.
Right.
And the only difficulty that sometimes private adjusters run into is if they don't reach that amount that is acceptable for you and you need to get legal counsel involved, then you have to hire an attorney to go and file suit. So just be mindful of that, of the relationship if you're hiring a private adjuster versus getting an attorney involved. We work with a lot of them. My law firm has. I know if you work with other attorneys, we have as well, and they can be a good working relationship there to kind of divide duties and then be able to properly handle the claim for them.
Right.
And then contractors, who you're going to be using, be mindful of who you have used previously in trust versus companies coming into the area for the first time.
Right.
Just again, there's a lot of good contractors in the area that are trustworthy that you've worked with. Just remember that if you've got companies coming in promising the world to you, and whether you have that working relationship with them versus the companies that you've been working with. I think there's a lot of value for that in the areas. There's a lot that goes into it that they'll be willing to put it in writing what they're willing to provide to you versus promises that might be made. And then when it comes down to actually signing off on a document, it might be looking a little bit different than what they proposed to you in the first place.
Right. So I'd like to add on this, in this information, Ed, remember that timely reporting your claims, and I know we're going to talk about that, but the insurance carriers are going to assign typically a third party to come out and adjust the claim. And they have those CAT adjusters is what they're called that understand the protocol. But it's really important to know that your insurance carrier is going to come out and do an inspection. And if you have a relationship with a contractor, then the contractor and the insurance carrier can work together and resolve your claim. And obviously the significance here is let's minimize, for the lack of a better word, let's minimize the drama and the confusion, and let's understand, like you said, what has occurred, what type of damages do we have, and who do we need to engage with from the beginning to protect ourselves as an association and as a community.
Be mindful of that too. If there is a communication and they're asking questions about prior maintenance and prior damage, because that can be used later against you. And and really on the next slide here, I believe, under your rights, be prepared for a pre-existing damage response. That's the last bullet point that I have. But one of the common things that we've seen in cases where we've had to get involved, where claims are filed and they're litigated, is there's some type of claim for pre-existing damage, construction defects, for example. And so just like whenever, even if you get in a car accident and you're contacted by the carrier and they start asking you questions, right? They want to, that is going to be filed away and it can be used against you later on regarding whether or not it should have been reported under a previous claim or whether it was related to this one. So again, be careful as to what you're saying. Read your policy, call your broker, or establish a procedure with management on how claim will be filed. So again, we kind of talked about this, procedures in place. Who's going to be the point of contact? How will this be handled? Make sure that it's in writing and that you have it on file and everything.
So when Ed was talking about read your policy, every insurance policy has claims reporting provisions that you need to be aware of and comply. And like Ed said, we need to talk about and have a pre-established plan as who is reporting that claim to the insurance carrier and what type of information are you providing. That's probably one of the most critical steps that you're taking to be on the road to recovery. But again, understanding the damages that you have and the situation you may be facing and making sure you engage up front with everybody that you need to engage with.
Yeah. Communicating in writing wherever you can. Again, that's where you're controlling what you're stating so that if it is used later on, that you're choosing your words carefully and that you know that you can set up a basis for trying to resolve it, for example. Timely file the claim. I sent out, if some of you received this, reminding people that we're coming up on 3 years from Hurricane Irma, which is really kind of the last date that you can file generally. But we were talking before we started, right? Under, what was it, under Lloyd's maybe, that
Right.
Can you talk about that a little bit?
Yes,
Yeah.
absolutely. So like I was mentioning, your policy is going to designate who you report the claim to and in a timely fashion. And it may even be defined within the policy. Particularly, Ed and I were talking about if your insurance renews in the summer, you've got damage, then you renew your policy. You need to make sure that your carrier, both the carrier you were with at renewal, and then if you move midterm, you're going to make sure you understand that there could be exclusions for pre-existing damage. So you need to absolutely make sure that you understand the policy, the loss reporting provisions in your policy. Your agent can walk through that with you. And again, determining who is going to be that point of contact for the insurance carrier. Yeah. And also keep in mind, you might be reporting under multiple policies. So that is another critical thing is when you're gathering all this information, understand from your agent how you're going to report these claims. If you've got 12 buildings and you've got 12 flood policies and you don't know if it's building 4 or building 6 that has flood damage, I'm going to say report it under all of them just to protect you, because you don't want to have a lack of reporting to cause a headache at a future date.
So the last couple bullet points, and I'll expand on some of this, utilize legal counsel. I would say that it's not your normal pipe burst claim where it's a pretty identifiable, what's the cause of it, and then what's the subsequent damage. You might have multiple adjusters, depending on if you're filing under multiple policies, it's more complicated. I'll put it that way.
Absolutely.
Right?
Absolutely.
And sometimes we find that if you get legal counsel involved, and obviously a good public adjuster, if you hire one, that you can keep the assigned adjuster on task and keep the claim moving. The other thing too is that if there's an argument and they're trying to play games as to, well, we think that it's worth this much, but they're not, carriers are supposed to pay you the undisputed amounts. And so even if you have a difference of saying, we think it's $1 million worth of damage and the carrier says it's $500,000 worth of damage, even let's say that's above your deductible, for example.
Right.
The carrier needs to write you a check right away for that $500,000.
Right.
If they don't, that's one of the bases for bad faith. And so in terms of there's a legal strategy going forward versus proving the amount of damage, but also whether or not you can prove a bad faith case, which really comes in after. It's something that you do after the initial claim. But I think having the right team involved to make sure that you maximize the amount that you're able to recover based upon this event. Right. The other thing that we found too is helping to communicate. I have clients, and I think some might be on this call too, where they've gone through this storm event, you get your recovery, you have your deductible, of course, and the question is, well, we don't have quite enough because obviously the deductible is your self-insuring portion of it, right?
Right.
How are we going to pay for that if we don't have enough in reserves? One thing is to communicate with your owners, especially in a condo association, if you have loss assessment coverage. I think the minimum, if I remember right, is $1,000.
$2,000
$2,000, okay.
Yep.
So, and one thing is I think is just beneficial is knowing how to communicate that to your owners to provide them with that info so they can go to their carrier and make sure that they can report it properly and get that to help. So if there is going to be a special assessment, that it's not going to all be borne by the owner, that they can kick in under their own policies, for example.
That is a great point, Ed. And we always want to make sure that encourage your owners to have insurance. Not everybody's going to choose to insure in a condominium association, but if you do insure and you have that $2,000 benefit, and many policies allow you to buy up, so you aren't necessarily saddled with a $2,000, but that is the minimum that's mandated, and that can go a long way in funding deductibles. Yep. And but the other piece of that is that the owners have to also put their personal carriers on notice of the claim.
So when we talked about the preparing for pre-existing damage response, and there's a whole other, we could talk more about the mechanics of a claim in the lawsuit if you have to go that far. The main thing is just note that it comes down to a battle of experts, just like a lot of other cases where they'll have a contractor that says that you can get the work done for X, R says Y, that you properly document it and move forward. The nice thing that you still have in Florida that you don't have in every other state is that it's basically a one-way door for attorney's fees. Once you have to file suit, where essentially, and kind of paring it down a little bit, if you recover more than what the carrier had offered you originally, and you have to go to litigation, your attorney's fees for getting there are paid for by the carrier. If you don't get more, though, there isn't a a revolving door where now the carrier gets their fees back. There is that provision in the AOB law. Now, so if you proceed under an AOB claim, that an assignment of benefits that is otherwise proper and it complies with the 2019 revisions, that was one of the abuses as well. There's so many assignment of benefits because lawyers would say, we'll handle this for it because we know that our attorney's fees are going to get paid if we get $1 more than what the carrier offered.
Right.
Now, if you file it as the association, you still have that ability to recover attorney's fees on it. And so that's the other tool that you have when you're bringing these claims against the carrier.
Right.
Yeah.
So I think that the message to take home from this today is understanding who you need to engage and when you need to engage them.
Yeah.
Your insurance agent should be working very closely with you to make sure all of your claims are reported properly and timely, and then working with you too through that whole investigation and inspection process and advocating to get those payments made quickly for you. And I know also that we have some insurance agents on the call today and the webinar, and I think all of us agree that we are always advocating for our client and doing the best we can to get those payments made quickly and to get everybody back on the road to recovery. But as Ed mentioned, it's critically important to know who you need to engage from the very beginning, and having those relationships where you can pick up the phone and have your insurance agent, your attorney, your property manager, your
Right.
boards on the phone and making those critical decisions before you get so far down the road that then you have other problems that begin to arise.
It's kind of and I teach a board certification class for new board members, and one thing I always say is, this is for our board members. You took on this job, you're a volunteer, you don't get paid for this. You have professionals that you work with, and Pilar just mentioned you've got attorneys you work with, CPAs, insurance agents, your management companies, your landscape, you can probably list 15 different
Right.
business types that you work with. So you're not alone in this. Make sure that
Right.
you rely upon the people that you've engaged with and that you trust to make sure this handled. It's the same thing from our managers and I'll speak for our managers that I know that sometimes when I've talked to some managers, they feel like, hey, our board feels like we know that we have to do everything ourselves. And it's not the case either for
Right.
managers. Managers have a great job of having a good, reliance on the people that they work with in the industry that they know to do a good job and what management can do versus one to turn it over to those other professionals as well.
Exactly.
So I know we have a lot of managers on too. You're not alone either. Let's all work together as a team for your clients.
Right.
Like Pilar said, there's a lot of people in that if you have the procedure in place where you kind of know everybody's role in it, it's going to make it go a lot more efficiently. And I think it's going to help you if you do have to file a claim.
Right.
Yeah.
Exactly.
So
Questions.
So with that, I'm going to leave this up. It has our contact information, and we have some questions that we're going to go through here. So Richard asked, does an HOA or condominium have any ability or requirement for each unit have contents, AKA renter insurance? So there is no requirement. They put that in, I want to say within the last 10 years. It's
and then took it out.
It was 1 year that they had, and you could probably speak to this even better. I imagine when there's a requirement, and if you didn't get, the association could force place that coverage. And I think
Right.
there were issues with actually getting that into place.
That's right.
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 So there is no, at least per state statute. Now, what I will say is you may be able to amend your governing documents to require it. And you may have that as a requirement. And if they aren't able to provide proof of it, could that be the basis of a fine? I could see that being
Possibility.
That could be a possibility. But in terms of from a statutory standpoint, there's nothing. They tried it for 1 year and they got rid of it. Deborah asked, can you, before the storm and there's an evacuation order, have management firms send out a request for residents not evacuating, provide their name, unit number, and the emergency contact? I think that that's perfectly reasonable.
Yes.
Again, it's optional for the owners to do that, but I think that's a good step to take to say, hey, the reason why we're asking for this is because we want to have a good contact list if we don't have it already, or if you're new in here, or if you haven't updated it, that we can have it in place so we can contact you.
Absolutely.
Yeah. Dave asked, can an association authorize within its documents voting by email? Unfortunately, no. It's actually in both the Condo Act and the HOA Act that specifically says you're not allowed to vote by email. You're allowed to, the statutes say that you can discuss items by email, but you cannot use it for voting. So just be mindful of how much you discuss by email so that you're not making decisions there, so that members are feeling like they're taken out of the process, because it's supposed to be by nature, everything's involving the membership, or at least in front of them. Even if they can't dictate what the board does, they should be able to at least witness the deliberation and how the board's making their decisions. Yeah.
Right.
Okay, I think Deborah asked, this is a multiple question there. Dan asked, should we sign an AOB with a contractor from our state? If it's somebody that you trust, there is a way that you can sign an assignment of benefits, but it needs to comply with the new requirements in the state statute. I didn't go through all those requirements, but they're pretty lengthy in terms of what you have to do for it. It's possible. And I think that if your contractor that you trust and that you work with is willing to do that, I think that it could be done properly. I would involve legal counsel to make sure that it's a proper, just like a lot of other contracts. If you're binding yourself, the big thing is you want to know what the scope of work is going to be, and which is required, and what they're going to be claiming from the carrier, and you want to make sure there's no out for them to be able to come after you if they can't recover everything from the carrier.
Right.
That's one of the big things. So yes, you are able, and it can be from out of state too, but the main thing is you want to trust the company that you're working with. And if they're willing to go through all the hoops for what the current law is, I think that it's okay as long as everything's proper and it's reviewed by legal counsel.
Right.
Yeah. And Ross, I did not pay him to say this. Ross is a president for one of our communities. He said, outstanding presentation. I appreciate that.
Thank you.
Thank you all for attending. I will be teaching some more webinars in the future. Pilar and I are both we're actually on the programs committee for our Northeast Florida chapter for CAI. And it's a little bit different right now. We're doing these webinars. So if you're a member of our chapter, take a look at that. If you're not a member, we'd encourage you to look at joining, and we'll be doing different webinars, but I know we'll be doing things down the line.
Yes.
So,
right.
And again, here's our email information. If you'd like to email us, I'm happy to provide you with a copy of the PowerPoint. And then take a look on our webpage. It's flcalegal.com. There's a little YouTube link in the top right. I have some other videos, but this will be posted in the next day or two.
Great.
So, all right. Well, thanks, everyone.
Thanks, everyone.
We're going to be ending this. All right.